welcome to you all. I'm Sarah Biddulph, the Director of the Asian Law Centre at Melbourne Law School. I'm delighted to co-host this conference on the law of the state of emergency with our colleagues and friends at Vietnam National University School of Law, in cooperation with the Institute of Legislative Studies under the Standing Committee of the National Assembly of Vietnam. I acknowledge the Wurundjeri people of the Kulin Nation, on whose unceded land I and Melbourne Law School are located, and I take this opportunity to pay my respects to their elders, past, present, and emerging. An online forum such as this provides us with a unique and precious opportunity to welcome participants from across the world. We have a large number, I think 30 or more, interesting and very insightful papers to discuss in this conference. And I think that this is really the beginning of a conversation and an opportunity to meet and engage with many new and old friends and colleagues. Can I encourage you, please, to visit the Asian Law Centre's website, where we have all of the papers up, and to give you an opportunity to read them so that you can participate more fully in the discussions as the panels proceed over today and tomorrow. I'm delighted also that both the Dean of Melbourne Law School, Professor Pip Nicholson, and the Dean of the School of Law at Vietnam National University, Dean An, are able to join us today. So now, please let me hand over to my friend and colleague, Professor Vu Kong Zhao, from the School of Law at Vietnam National University, to welcome them.
Thank you very much, Professor Sarah. Following the wonderful introduction of Sarah, allow me to once again to express our sincere thanks to everyone here, including the paper author, the chairperson, the participants, and the member of the two organizing team of the conference in Melbourne Law School and the VNU School of Law. Also allow me to briefly introduce Vietnamese participants and speaker. Regarding the participant, firstly, I would like to introduce Associate Professor Nguyễn Thị Kế Anh, the Dean of our School of Law, VNU, who will soon deliver welcome speech on our behalf. I would also like to introduce many professors, lecturers, PhD, master and undergraduate students from the VNU School of Law and from some other law school in Vietnam, as well as from the some state agency of Vietnam. Particularly, I would like to introduce Associate Professor Vũ Hồng Anh, the former member of the National Assembly of Vietnam, who is here as a representative of the Institute of Legislative Studies under the Standing Committee of National Assembly of Vietnam, the agency that is now being collaborated with us in organizing the conference today. Especially, I would like to introduce and extend our sincere thanks to all participants, speakers, and chairpersons from many countries outside Vietnam and Australia, including those from United States, UK, Iceland, Canada, Italy, Japan, China, Singapore, Thailand, and Indonesia. We are very grateful and appreciate your participation and contribution to our conference. Now I need to give the it's time for us to hear important addresses from the teacher, from the leader of two co-organizers of the conference. Firstly, I would like to invite Professor Pip Richardson, the Dean of Melbourne Law School, to deliver the first welcome speech. Thank you very much.
Absolute pleasure for me to welcome you all to this joint conference. I am delighted to be working again with Dean Nguyen Thi Quy Anh and my dear friend Vu Kong Zhao on the delivery of the significant conference looking at law on the state of emergency. As both Professor Zhao and Professor Sarah have said, we are thrilled to have international engagement on this significant issue and excited but also heartened, I think, to see the collegial coming together to debate the fundamental legal issues that our times have provoked. As always, my law school has had a very strong and enduring partnership with scholars and policymakers in Vietnam. And I see this conference as a testament to the longevity of that relationship and the commitment to nurture it over the years ahead, but also to nurture relations with scholars across the region and across the world. I am particularly pleased that from Melbourne, we have representatives from both the research communities working on health and law. So I am indebted to the participation of both the Health Law and Ethics Network and also the COVID-19 Legal Research Network, which was recently established. So thank you to my colleagues in that area. My final wish is that the conversations are deep, that they are many and fruitful, and that there is a sense of purpose and partnership at the end of this conference that can sustain us over the months and years ahead. So I wish you well, and I'll hand back to Professor Zhao.
Attending the conference today.
Thay mặt khoa luật Đại học Quốc gia Hà Nội, chúng tôi cũng xin gửi lời chân thành cảm ơn tới Trung tâm Nghiên cứu Luật Châu Á thuộc Trường Đại học Melbourne, đặc biệt là giáo sư Saras và bà Catherine Taylor đã nhiệt tâm hỗ trợ phối hợp cùng chúng tôi để thực hiện hội thảo này.
On behalf of the School of Law under the Vietnam National University Hanoi, I would like to express our sincere gratitude to the Melbourne Law School, the University of Melbourne, Australia, particularly Professor Bimos and Professor Sarah.
Chúng tôi xin cảm ơn các bạn tham gia phối hợp để tổ chức hội thảo ngày hôm nay.
We would also like to display our gratitude to the leaders of the Institute for Legislative Studies under the Standing Committee of the National Assembly of Vietnam, who have joined us to make this conference a reality today.
Kính thưa toàn thể các quý vị đại biểu, các chuyên gia, năm 2020 chắc chắn sẽ đi vào lịch sử nhân loại của mỗi chúng ta theo một cách vô cùng đặc biệt, và hầu như tất cả chúng ta ở đây theo một cách nào đó thì đều là nạn nhân của đại dịch Covid-19.
The year 2020 will surely enter human history and our own personal histories in so many special ways. All of us here today are, to some extent, the victims of the COVID-19 pandemic.
Ở thời điểm hiện tại, dịch bệnh vẫn đang tiếp tục hoành hành ở rất nhiều nơi, và ban tổ chức hội thảo này xin được gửi lời chúc bình an, sức khỏe tới tất cả những người dân và các chuyên gia hiện đang ở các quốc gia mà dịch bệnh vẫn chưa hoàn toàn được khống chế.
Right now, as we are speaking, the pandemic is still spreading in many places. On behalf of the conference organizers, I would like to wish peace and health to all those citizens and experts currently living in the countries where the pandemic is still not under control.
Ở Việt Nam của chúng tôi cũng không hề là ngoại lệ và cũng là một trong nạn nhân của đại dịch này. Trong suốt nửa năm qua thì chính phủ và người dân Việt Nam đã áp dụng rất nhiều biện pháp chống dịch khác nhau và bước đầu đã đạt được một số những thành công đáng khích lệ. Tuy nhiên, có một vấn đề đặt ra, đó là hành lang pháp lý cho việc ban bố và hành động của trong cái bối cảnh tình trạng khẩn cấp của chúng tôi cũng chưa thực sự được hoàn thiện. Và dường như pháp luật thì chưa có sự chuẩn bị tốt nhất cho những sự kiện tương tự như thế này. Không chỉ ở Việt Nam mà theo chúng tôi được biết, ở nhiều nước khác tình trạng tương tự cũng đã xuất hiện trong bối cảnh hiện nay.
Vietnam is no exception, and we are also the victims of this pandemic. Over the past 6 months, our government and citizens have adopted many different methods to mitigate the pandemic. And for now, we have achieved promising results. However, one critical issue emerged. Our legal framework relating to declaration of state of emergency or taking action is not yet completed. It seems like the legal framework is not well equipped with such events. This situation applies not just to Vietnam, but as far as we are concerned, also to other countries.
Đứng trước bối cảnh đó thì khoa luật Đại học Quốc gia Hà Nội vinh dự được phối hợp cùng với Trung tâm nghiên cứu luật châu Á thuộc trường Đại học Melbourne của Úc và Viện nghiên cứu lập pháp thuộc Ủy ban Thường vụ Quốc hội Việt Nam tham gia tổ chức hội thảo đặc biệt này với mục đích là phân tích đánh giá thực trạng và đưa ra những khuyến nghị giúp cho Việt Nam cũng như là chính phủ các nước khác hoàn thiện khung khổ pháp lý nhằm đối phó với những tình trạng khẩn cấp có thể tiếp tục sẽ xảy ra trong tương lai.
In such a global situation, VNU School of Law is honored to join with Asian Law Center under the Melbourne Law School and the Institute for Legislative Studies under the Standing Committee of the National Assembly of Vietnam in organizing this special conference. We aim to analyze case studies and offer recommendations to help the Vietnamese and other governments to complete the legal framework specialized in dealing with such a global situation that may take place again in the future.
Là một trường luật có uy tín và có truyền thống lâu đời nhất ở Việt Nam, khoa luật Đại học Quốc gia Hà Nội chúng tôi luôn luôn không ngừng nỗ lực hội nhập và tạo cái sự phát triển, đóng góp vào cái sự phát triển chung của luật học trong khu vực và quốc tế. Và rất may mắn cho chúng tôi là trong quá trình đó thì chúng tôi luôn nhận được sự đồng hành, sự hỗ trợ nhiệt thành và hiệu quả của các bạn bè, đối tác và các nhà khoa học uy tín trong nước và nước ngoài.
As the law school with the longest tradition and high reputation in Vietnam, our law school has always tried our best to join with the general development of legal studies in the region and in the world. Fortunately, during this process, we have always received the kind and effective support from our partners, friends, and scientists, both locally and abroad.
Chẳng hạn như cuối năm 2019 vừa qua, khoa luật Đại học Quốc gia Hà Nội đã vinh dự cùng Hiệp hội Luật Hiến pháp châu Á tổ chức diễn đàn Luật Hiến pháp châu Á những phát triển gần đây và xu hướng tương lai lần đầu tiên tổ chức tại Việt Nam, và với sự tham dự của hàng trăm học giả đến từ gần 30 quốc gia và vùng lãnh thổ. Và dự kiến của chúng tôi là sang năm 2021, chúng tôi sẽ phối hợp với Hiệp hội Luật và Xã hội châu Á tổ chức một hội thảo quốc tế tương tự như vậy nữa ở Hà Nội, và rất mong sự có mặt của các quý vị đại biểu.
For example, at the end of last year, 2019, our school were honored to organize with the Association of Asian Constitutional Studies, entitled Asian Constitutional Law, Recent Developments and Trends, with hundreds of scholars from nearly 30 countries. With the Asian Law and Society Association, we are also planning to organize a similar international conference in Hanoi next year.
Hội thảo này tuy có một quy mô khiêm tốn hơn so với các hội thảo mà chúng tôi đã đề cập trong cái bối cảnh đại dịch vẫn đang hoành hành hiện nay. Tuy vậy cũng đã quy tập được hàng trăm học giả, giảng viên, nghiên cứu sinh, học viên và sinh viên luật ở Việt Nam cũng như là các quốc gia trên thế giới. Chúng tôi rất là vui mừng vì đã có sự tham dự rất đông đảo như vậy của các quý vị đại biểu, và chúng tôi cũng mong rằng là nó sẽ hứa hẹn những cái thảo luận sôi nổi và đưa lại những cái thông tin, những sự hữu ích cho tất cả chúng ta.
This conference, although it is smaller in scale than the conferences mentioned above, also boasts hundreds of scholars, lecturers, PhD candidates, and law students in Vietnam and tens of countries in the world. Therefore, we look forward to lively discussion and to knowledge and information useful to all of us.
Một lần nữa tôi xin thay mặt cho khoa luật Đại học Quốc gia Hà Nội xin gửi lời cảm ơn với tất cả các quý vị đại biểu, các chuyên gia, các nhà khoa học, các đối tác đã dành thời gian để tham dự và phối hợp để tổ chức hội thảo trong bối cảnh rất đặc biệt này. Và một lần nữa, chúng tôi xin gửi lời kính chúc sức khỏe, bình an, thành công, hạnh phúc tới tất cả các quý vị đại biểu. Xin trân trọng cảm ơn.
To not lose any more time for the conference, I would like to end my speech here, and once more, on behalf of the VNU School of Law, I would like to thank you all for having the time to join us and help us organize the conference in such a special time. I respectfully wish you all health and success, and I wish great success to our conference and that we achieve our goals. Thank you very much.
Thank you for your attention. Thank you.
Thank you very much, Associate Professor Nguyễn Thị Quế Anh, and also again, thank you very much, Professor Pip Richardson, for the wonderful speeches. Now I think I need to give floor to Professor Sarah, who will tell us briefly about the administrative arrangement for the conference. Thank you very much.
Thank you very much. And thank you to the two deans for your inspirational words of greeting and encouragement for our conference. So we find ourselves in a very unusual time. We would prefer to meet face to face, but as we cannot, we have proceeded online, and I think many of us have had to adapt very quickly to online conferences. So I'd like to share with you some of the administrative arrangements of this conference so that we can proceed as smoothly as possible. The first is to let you know that we are recording this conference so that we can put it online and share it with more people who might not have been able to attend. This conference goes over 2 days and it will be 3 hours over 2 days. We thought that that's probably as much Zoom as any of you could put up with. So on each of the days, we'll have 3 hours and 3 panels. So each panel will be around 50 minutes long. And each of those panels, we have a chair. And before we start, I would like to express our deep gratitude to the chairs, because the chairs of every session have read all of the papers in advance and prepared notes and questions for each of the speakers, which they have already distributed to the speakers, so that they have a chance to prepare what they would like to say in response to those questions. So thank you to each of the speakers, or each of the chairs who have done this work. And also I'd like to thank all of the speakers. We have a fabulous collection of papers that have been available for some time now to all participants in this conference, so that everybody has a chance to read the papers in advance and to think about them. And I encourage you, if you haven't read them, to dip in and out and have a look at the papers as we go along. So the format for this conference may be a little bit new for many people, and we've designed it specifically because it's an online forum. And in formulating these administrative arrangements, we wanted to ensure that everybody had a chance to participate. That is, all of the speakers had an equal chance to speak, and that also we maximised the opportunities for discussion. And so you will see that we appear to have done something very dictatorial, which is to ask every speaker to confine themselves to 3 minutes. We hope that you will cooperate with this time limit, because we think that this will contribute to making the conference vibrant and successful, and also to increasing the amount of time that's available for discussion. And I think there's another slide. Yeah, so the way in which each of the panels will operate is that the chairperson will provide a summary of the main ideas and the themes. They will ask a question of each speaker, who will be able to respond to that question and at the same time discuss their paper. That, we hope, will then leave us with 20 or 25 minutes in each session that will be devoted to discussion about the papers. And we would encourage everybody who's attending this conference to participate by writing your questions into the chat section of Zoom. So I've seen already that there are lots and lots of chats coming in, so I think that you probably already know where the chat function is. But if you don't, it's at the bottom of your screen with the heading chat. So if you click on that, you'll see a new bar comes up and you'll be able to write your question in. So when we get to the discussion time, we'll be able to read these questions out in the right order. So please, if you have a question, write it in as quickly as you can. And just to remind you that if you're not speaking, if you wouldn't mind please muting your microphone so that it limits the feedback or the interference noise that happens, that might happen if it's on. So I think they're all the administrative arrangements. And so now I'll hand back to Professor Zhao.
Thank you very much, Sarah, for very, very clear and concise instruction. I think now, please allow me on behalf of Professor Sarah to declare the end of the opening session of the conference so that we can move on to the discussion panel. The first panel includes very interesting paper on the state of emergency in the constitution and law of some many countries. So I would like to invite Professor Sarah, the chair of the panel, and the panelist of the first panel to start our work. Thank you very much.
Thank you. So now I'm the chair of the session. Thank you and welcome to the first session. So welcome to this panel discussing how emergencies interact with and impact on the functioning of the Constitution and constitutionalism in different countries. For the participants and speakers alike, if you would like to ask a question, please type it into the chat function, which I just mentioned in the introduction. Again, we've restricted each of the speakers to 3 minutes so that there'll be plenty of time for discussion. So, the questions of emergencies and its relationship to the basic principles of constitutionalism and the related question of legislation direct our attention to questions such as the specific legal mechanisms that define when an emergency can be declared, how, and for how long. Importantly, constitutional and legislative principles tell us what powers are given to state agencies, how they can be used, and what are the limits to those powers. These are questions of fundamental importance to the relationship between the state and citizens and to the protection of human rights. In this panel, the focus is on constitutional and legal issues. We have another panel immediately following this one that focus on the questions of human rights. So we're fortunate in this panel to have an excellent set of papers that discuss these issues from a range of perspectives and in relation to several different countries: Japan, Singapore, Italy, and Vietnam. I'll not introduce the speakers in detail, but you will find their biographical details in the conference website. So, Professors Dong and Dang's paper points out that a state of emergency at its heart privileges executive power at the expense of the rights of the people. It is, they say, the power to protect the legitimate existence of the whole nation, whatever the cost. They give examples where emergencies have been declared, even in the absence of clear constitutional authorisation. Using a wide range of examples, they point out a fundamental tension between emergencies and constitutionalism, emergencies and the rule of law. Professor Tsuchi's paper demonstrates in the case of Japan, like many other countries, the government had existing powers to declare an emergency lockdown for COVID-19, but was reluctant to use it for political reasons. This paper argues that emergency declarations should not be made outside or above the law, but should always be constrained within the bounds of law. In Japan, there were also important constitutional and legal limits to the government's power to take coercive measures during the pandemic. Professor Lee's paper notes that the Singaporean government did not declare a state of emergency as part of its strategy to combat the COVID-19 pandemic. This situation highlights differences with other jurisdictions and raises a question about when does an emergency or crisis, is it sufficiently serious to warrant the use of emergency powers? And we see that this answer differs in different countries. Professor Dutt's paper discusses constitutional principles relating to emergency law in Vietnam. This paper discusses the legal and constitutional principles that apply to frame emergency laws and still enable limitations to be imposed to protect constitutional rights. Professor Amaranti's paper raises an important perspective on the pandemic, which is its interrelationship with environmental degradation. This perspective demands that we change our current focus, which has naturally fallen on the nation state and the use of emergency powers by each state to control the pandemic within its own borders. It points out that environmental degradation and the precautionary principle in international environmental law should be central to our thinking about the COVID-19 pandemic and the path to recovery. And finally, Professor Hin's paper discusses the impacts of the state of emergency on land requisitions, one of citizens' fundamental rights. It raises the difficult issue of the circumstances when it is appropriate and lawful for the state to requisition land and the calculation of compensation that is fair. So now I would like to direct questions to each of the panelists. So for Professors Dong and Dung, my question, in your paper, State of Emergencies in the International Convention of Human Rights and the National Constitution, you make a very important point that there are limits to the power of the executive to derogate from citizens' rights and the principle of legality enshrined in both international and domestic law. Would you tell us something more about your argument about the proper limits on executive power and how a balance between executive power and protection of human rights is to be found? And also, please say something about how executive power and citizens' rights has been balanced in Vietnam during the COVID-19 pandemic. Thank you.
Very an honor for us to answer very first questions in very first sessions. So I'm a little bit nervous. So in the paper, we have tried to explain why the executive should be empowered with the right to declare the state of emergencies. However, some example from history have already shown that the application of emergencies power may violate human rights. As we mentioned in the article, the executive order signed by President Roosevelt in World War II that authorized the Secretary of War and the armed forces to remove all people of Japanese ancestry from designated military areas and surrounding community in the United States that violate right to non-discrimination, which now has been considered as absolute right. Therefore, we both state that the emergency power of the executive should be appropriately limited according to the law. In particular, the derogation of right must be regulated in national constitution and national law as well, incompatible with international law on human rights. In addition, the legislative may control over the exercise of the executive emergency power by ratify, modify, or abolish the emergency declaration later. In other words, in urgent situation, the executive is obliged to protect the life of the nations by any means, even has to use the method that may against the rule of law, but cannot completely eliminate the rule of law. For example, the executive can declare to suspend the implementation of part of the constitution, but they can't suspend all the implementation of the constitution in the country. So the remaining branches of power still have authority to review the legitimacy of executive actions in the state of emergencies, and above all, the supervision of the people on the executive actions. For example, so the Supreme Court may review decisions in emergencies of the executive that may violate human rights of citizens. And some other example that we analyze in the paper. In Vietnam, different than other countries, National Assembly or Standing Committee have empowered with the right to decide issue the issue of war and peace to annul states of emergencies and other special measures to ensure the national defense and security according to Article 17 in the Constitution of Vietnam. And the head of state, who is the president, has the right to declare what National Assembly decided. However, in Vietnam during the COVID-19 pandemic, we barely saw the role of either National Assembly Standing Committee or the president, because in urgent situation, it couldn't wait for the law to come into force. Instead, the Prime Minister has issued Directive No Sittings or social distancing, but the directive is not legal instrument according to Vietnamese law. So in this case, we recommend that the emergency power should belong to the executive. Design or method that has been applied in emergencies must be reviewed. For example, although Directive No 16 of the Prime Minister have effect on preventing the spread of the virus, but it also hinders citizen right implementation by imposing social distancing on whole territory without risk zoning. So that's my question. That's my answer.
Thank you so much. And thank you also so much for keeping your answer in the right time. It was a very interesting paper and a very interesting answer. So let me now direct the next question to Professor Darius Lee from National University of Singapore. In your paper, Singapore's legislative response to the COVID-19 emergency, you discuss a legislative model for emergency powers. Would you explain what this means and how it affected Singapore's response to the COVID-19 emergency, particularly in how it balanced executive power with the protection of citizens' rights? Over to you.
Sure. So thank you for the question. Now, just to explain a little bit about this legislative model. A legislative model of emergency powers is different from the typical state of emergency. In a so-called typical emergency, the executive branch of government declares a state of emergency, suspends the normal constitutional order, and is empowered with extraordinary powers for a temporary period of time. And emergency is known as an exception to the norm. But in a legislative model, the legislature enacts ordinary laws that delegate special and temporary emergency-like powers to the executive without suspending the normal constitutional order, including constitutional rights. So officially speaking, there is no state of emergency. But the danger of this legislative model is the risk of creating a so-called permanent emergency and undermining the normal constitutional order. Now, all of this is not new in Singapore. Examples of such permanent emergency or emergency-like laws include Singapore's Internal Security Act and Criminal Law Temporary Provisions Act, which allow for preventive detention on grounds of national security and public order, respectively. This is despite the fact that the government has never declared a state of emergency since independence in 1965. In response to COVID-19, Singapore did not invoke the emergency powers under Article 150 of the Constitution. Instead, on 7th April this year, Parliament passed the COVID-19 Temporary Measures Act, which I'll abbreviate as CATMA, which is valid for 1 year. Now, using the powers under CATMA, the health minister took sweeping measures such as restricting movement, closing workplaces, and prohibiting gatherings. The government called it a circuit breaker, which is actually a euphemism for a lockdown. Since CATMA is ordinary legislation, all the usual protections under the Constitution still apply. So in my paper, I examined 3 types of protections: safeguards within the Act itself, constitutional and administrative review through the courts, and extra legal measures through elections. I concluded that the most robust protections come from the ballot box, which are 3 elections, which must be held by April 2021, pursuant to the Constitution. And this is also about the same time that CATMA expires. Well, in practice, I observed that the government apparently balanced executive power with the protection of citizens' rights through flexibility in enforcement. So the government took a very calibrated approach towards the enforcement of the public health measures with a degree of sensitivity towards public perceptions. Apart from hard approaches like fines and jail terms for breaches of quarantine orders, it also used soft approaches. For example, the Prime Minister gave a national address, making a special appeal to the elderly to stay home. This approach reflects the prevailing constitutional culture, which is pragmatic, communitarian, and based on the notion so-called of government by honorable men. Singapore also reflects prevailing heightened sense of vulnerability as a small island nation state that experienced 2 states of emergency in the years before independence. So I hope that answers your question.
Thank you very much. That was a very interesting answer. Do we have Professor Amarante here from the University della Campania, Italy?
Yes, yes.
Yeah, thank you. So in your paper, Tangled Up in Green, the tight connection between COVID-19 and the environment, you rightly point out that the causes and impacts of the pandemic are inherently transnational. Would you say something more about your argument that environmental law principles are an integral, in fact, essential part of responses to the pandemic and the circumstances in which it occurred, as well as the future governance priorities? Thank you.
Yes, thank you for the question, and I would like also to thank the organizer for inviting me. For us from Europe, it's quite unusual to speak at a conference at 4 in the night, but it's okay. I'm very happy to be here. So, so let's. It's very difficult to answer back to your question, because when we speak of environmental law, people suddenly think of international law. In fact, the problem is that we must, from now on, reflect about environmental law in terms of constitutional law, I think, more than on international law. International law gives us a framework and some principle, but if we don't apply them and don't structure this principle according to every single national constitutional law, we're not going to apply environmental law correctly, and it will not be very on the spot. But the problem with COVID is that, as it has been defined and pointed out in my paper, maybe this is the first Anthropocene crisis, a general crisis, health crisis linked to environment degradation that is touching every single country of the world. And so we have to reason about what constitutional answers we have to give to this crisis. And we cannot compare this emergency with normal constitutional emergency that are war emergency or terrorism emergency, or even some health emergency of which we know the rules and for which we already have legislation, like for example in Japan they have for many natural disaster or other health crisis. The problem is that, and this is clear from environmental lawyer, we are in a precautionary principle scenario. That is to say, we have to face with scientific uncertainty. We don't know what to do. When the COVID started, we didn't know what to do, because we didn't know from where it was coming, what were the consequences. And so the problem was that we had to start a sort of a dialogue with the scientific parts and scientific experts. So here there is a different relation between public power, constitutional powers, and scientific data, because we cannot use science as such, like objective data, but we have to dialogue with science. So that's why the precautionary principle becomes very, very, very important. And I think we should get more some kind of deeply into the precautionary principle. Those crises are going to occur more and more frequently, I think, in future. So this is not just for COVID-19, but for the years to come. The precautionary principle plays a sort of an emergency role, requiring the public actor faced with a situation of necessity to make choices in any event, even if they are not supported by a scientific certainty. Here comes one of the main elements of the precautionary principle, the expansion of political and administrative discretion with regard to choices having an uncertain technical and scientific concern. But what it is interesting that we already have a clear understanding of the precautionary principle in environmental law, and this can be very useful for constitutional law because the precautionary principle should be considered within a structured approach to the analysis of risk, which comprises three elements. So risk assessment, so we have to include in our justification a risk assessment, a risk management, and of course risk communication. For example, in Europe the risk communication was very good and people accepted the measures and did not protest very much against them. So it was not felt as a violation of human rights or of fundamental rights, because we adopted somehow this kind of protocol about the precautionary principle. And then what is more interesting are the administrative steps that the European Union, for example, gives for applying the precautionary principles. Let me resume just the first, the 5 administrative steps.
Professor Amaranti, I wonder, would it be possible to make your concluding comments now?
Yes, yes.
I know it's 4 in the morning. Thank you for joining, but
yes. No, but just those steps: proportionality, non-discriminatory approach. The approach must be consistent with similar measures already taken, an examination of the potential benefits of the action, so the economic aspect comes. We didn't touch this, but this is very important, the economic aspects of the constitutional measures. And these measures must be subject to continuous review. As soon as we know more about COVID, we have to change our constitutional response, our legal response, our administrative response. We tried to adopt this approach in Italy, or at least to justify our approach to this, and it worked quite well. We've been touched by the COVID-19 very hard, but I think Italy has responded with very important measures that were not based on a constitutional provision on emergency, because we don't have such emergency provision in the Italian constitution, but that application of the precautionary principle was quite good, I might say, for us, because it responded to some of the necessity of rapid action in a potential risk and in an unknown risk situation. Thank you.
Fabulous. Thank you very much. And I'm so sorry that you have to be up at 4 o'clock in the morning, but thank you for joining. It's marvelous.
It was a pleasure.
Thank you. And so now can I turn please to Professor Hien's paper from Canto University in Vietnam. In your paper, Vietnamese Law on Land Requisition in the State of Emergency, you discuss the emergency circumstances when the state is permitted to requisition land. Would you tell us about the principles you argue should be applied to limit the way in which this power is exercised, and the measures that are needed to ensure that citizens' rights are appropriately protected? Professor Hien.
Thank you very much, Sarah. Hello, everybody. It's a very honor for me to participate at this conference. And thanks for the School of Law, Hanoi National University, and Melbourne University as well as to organize such a meaningful conference at this certain time. My paper about land requisition. According to Article 54 of the Constitution, paragraph 4, we discussed about land requisition. However, there are something short in there. The first thing I would like to argue is about the circumstances, the conditions to apply land requisition. And the Constitution, according to the Constitution and the law, we just say, Vietnamese law just say about the necessity, but I think the necessity is not enough, the circumstances. It needs to be the urgent necessity instead of necessity only. And because the first thing is to argue that because the ordinance on a state emergency of Vietnam still put in secret. So it's not in public. So it's difficult for you to know the emergency situation. And the second thing is the Constitution say that it needs to be regulated by law. But now we have two laws. It's due to be regulated by land law. Until 2008, we changed to the law of requisition properties. And after that, in land law 2013, we moved back to land law. So now it's very confused that which law in Vietnam regulate about land requisition. So the first point I would like to make clear about it needs to be regulate urgent necessity rather than necessity only. And the second point is about the compensation, because the Constitution doesn't say anything about the Constitution. So there is, it seems to me like no principles for the compensation when the state do land requisition. So I think it needs to put there the compensation must be fair, and especially the method how to make the compensation fair and how to make the all the damage must be compensated. All the damage caused by land requisition must be regulated there. For example, that when the land is destroyed by land requisition, which method to guarantee that the compensation is fair? Because in Vietnam, the land price is always the subject to discuss. So how to because there is a difference between the land price regulated by the government and the land price in the market. So how can you make the compensation is fair? So that's 2 points I would like to make clear. The first is the urgent necessity, and the second is a fair compensation when we dealing with land requisition. Thank you for listening. Thank you.
Thank you very much. It's a very interesting topic, something that I'm very interested in. Thank you for speaking. Now, I think that we might have Professor Tsuji back online. And so can I now ask Professor Tsuji if he would like to make his comments, please?
Yes, thank you so much for inviting to this conference. So I will be answer to your question. So government shall protect lives and property of the people. Government can change interpretation of text of a statute by cabinet decision. Also shall maintain a certain interpretation because certain change of interpretation may harm reliable interest and establish a legal order. So we need to maintain separation of powers. Government shall need to explain the reason of the change of interpretation of Influenza Special Measure Act if it changed interpretation. In this case, COVID-19, government frequently changed its attitude for definition under ISMA and failed to maintain legal stability and lost people's trust. So could you please to page 8? Yes, please 8. Yeah. So thank you for asking me to administrative guidance. It's a unique legal notion in Japan. This guidance is not a forced action, therefore does not need legal basis. This guidance is now under Administrative Procedure Act. Administrative guidance is exercised within administrative discretion. Discretion is allowed only if it's exercised within a statute. Arbitrary and capricious guidance is not allowed. So next slide, please. Advantage is it's a practical to require legal, impossible to require legal basis to all the government action. Guidance allows flexible and quick response in individual case. Bad point, it cannot force people to do something. It works only if peer pressure works. Thanks for listening, and I'm sorry for a bad internet connection. Thank you.
Thank you very much, Professor Tsuji. And I think that you don't need to apologize for the internet connection. Somebody else is responsible for that. So now can I turn, finally, I think Professor Dutt is now online to make your comments, please.
For your question. Your question is principles in Vietnamese law that balance the principles of rights protection with allowing for derogation of rights during the emergencies. My answer is very simple. It is the application of the principle of proportionality in rights limitation in making emergency law. And then I will explain my point. So regarding the constitutional basis, we have the Vietnamese constitution has a principle of human rights limitation at the Article 14. So it is a foundation for control over rights limitation in general and derogation from rights in states of emergency in particular. So I think about the applicability of the proportionality doctrine here. So apart from this provision, we have couple standards, like Professor here mentioned, are strictly necessary in the limitation on ownership right in states of emergency, as you can see in two other provisions here. And for emergency legislation and regulations in Vietnam now, they are very inconsistent and scattered in many acts and decrees as well. And for the application of the proportionality principle, I think we should follow 4 steps, as you can see here. And for all those 4 steps, the requirement for human rights limitation in emergency should be tougher, higher in general compared to in normal circumstances. So it is my conclusion. Thank you.
Thank you very much indeed. These have all been marvelous and interesting comments and answers to these questions. And I see that the chat is full of very interesting questions. And so I think that maybe what I'll have to do is to start at the top, whose questions came first, and read our way through. But Catherine will save the questions that are in the chat, which means that we will have an opportunity to discuss those questions even after this session is finished. The next question is a question which is directed to all of the panelists. So let me ask it and see when we re-establish a connection with our colleagues at the School of Law. So the question is it possible to ask the panelists to comment about the suspension or otherwise of fundamental civil rights in their own country and the circumstances when those fundamental civil rights can be suspended? Would anyone like to answer that question? Is Professor Tsuji there?
Can I interpret Professor Zoom?
Please do, yes. Yes, sorry,
Yeah.
yes.
So very briefly, Professor Zung said that I have been teaching law for 30 years, but I haven't heard about any conference seminar like this. So Vietnam has the Ordinance of Emergency 2000, but it has never been used. And I think actually Vietnam has not need to use this ordinance. In fact, so we have more pressing, more necessary acts should be promulgated. That's my point.
Very good. Thank you very much.
Mm-hmm.
Japan has experienced many natural disasters, prepared for specific action via specific statutes. Consequently, a number of acts of the states of emergencies have been adopted. I wonder why Japan has not adopted an act to regulate the general principles of the state of emergency. So why is there no general law of emergency in Japan?
Yeah, thank you for asking these questions. We, a Japanese scholar, would argue that the separation of powers should be maintained. We should not adopt a general statute to allow government to declare state of emergency, because we are so afraid may make a mistake to infringe civil rights. For COVID-19, even those who want to adopt general state of emergency in a statute say we need this to protect the civil rights of the people. I think this would be answer to his or her question. Thanks for asking.
Thank you very much. It's a very important topic, I think, in Japan, the protection of civil rights and the circumstances when the government is morally, not just legally, entitled to infringe on those rights. I have a question now for Professor Darius Lee. Your argument about the ballot box being the most important check on the government's legislative approach to COVID-19 is very interesting. Could you discuss the provisions and protections in place during the Singaporean elections to ensure that issues associated with the government's handling of COVID-19 are fully and openly discussed by the opposition parties and candidates? So, Professor Lee.
Yeah, so thank you for the question. Now, my argument on this front is actually more pragmatic than principled, and it actually bears some resemblance to Oren Gross's Chaos and Rules, where he talked about extra legal measures. So in terms of Singapore's elections, it's likely, first of all, to be a referendum on the government's handling of the COVID-19 crisis, and secondly, to confer a mandate in a post-pandemic world. But when it comes to the upcoming elections, so Singapore is building towards that right now, currently this is a problem because this is basically an unprecedented crisis. The rules are actually not clear, and the opposition parties have actually raised questions about the rules on campaigning. Online campaigning, which is likely to be the way that campaigns will take place this year, that is actually a gray area in Singapore. The rules, as far as they've been drafted in the statutes, generally affect campaigning in person, campaigning at a public location, but when it comes to online campaigning, the rules actually are not that clear as to how they do actually apply. So when I talk about that, I think it's going to be an issue. And for those people who know something about Singapore's history as well, Singapore has been a one-party state basically since independence. And there have been many ways in which the oppositions have been, shall I say, marginalized, suppressed sometimes through defamation suits, and so on and so forth. So when it comes to all of this, shall I say, it's a more relative argument that I'm making to say that elections are likely to be the most robust kinds of safeguards against the use of these legislative emergency powers. But on an absolute standard, it's not going to be that strong as well. So that, I think, is a good question. And I think that's an issue that Singapore has to struggle with and is still struggling with right now.
Thank you. Thank you very much. There are so many questions here. I've asked Catherine to save the questions so that they will be available for discussion at a later time. But I'm mindful now that our time is up for this panel. So let me please thank all of the speakers for your very interesting presentations. Thank you very much for preparing so well in advance and sharing with us such a range of interesting and thought-provoking ideas.